Hello, everybody. If I am audible to all of you, just give me yes. If I am audible to all of you, give me yes. If I'm audible to all of you, give me yes. Hello, everyone. This is Sudipto, and today we're going to talk about next part of the previous case, State of Tamil Nadu versus Governor of Tamil Nadu. It's a very important case, as all of you know it. I was talking about this aspect. But before getting into that, I need to tell you one very important thing. Research is going to turn 9 tomorrow, 15th August. I started it 2016, 15th August. I never thought it's going to be that wonderful opportunity to serve you people. When I started it, there was nobody who was in India who were helping CLAT PG aspirant comprehensively. So we are the first one to start it with that. And then after that, we have been able to help you, and we are helping you. We're going to help you in the future in a lot of other ways possible. And thank you for your love and support always, and hope to carry forward this cooperation together in the future as well. Okay. Now, because of this jurisdict event, okay, there is an offer going on, 15% discount offer is going on. Agar aap any courses you are going to go for it, the 4-5 days offer period is there. You can go for it. Okay, the discount period to avail the discount itself. Okay, but a lot of things I have already talked about. Now let's get to the main point. Okay, this judgment, which is very important for your CLAT PG preparation. Okay, but today we are going to talk about this judgment in detail, the second part of this judgment. Okay, now इस जजमेंट के बारे में मैं बहुत सारा चीज बता चुका हूं प्रीवियस क्लास में. I have shared with the facts of the case. I have shared with the law that is attached with this particular case. Okay, उसके बारे में बताया हूं. जैसे आपके article 200 is one of the aspect that I have talked about, and I have talked about the facts of the case. So if you haven't watched that video, I want to definitely recommend to go for that video first. Okay, the first part. Today, I'm going to talk about the second part of that particular video, okay, where I'm going to talk about the two major issues. Then in the coming class, I'm going to talk about another 2 issues or 3 issues down the time. Now, this particular State of Tamil Nadu versus Governor of Tamil Nadu, this is one of the important judgments that I have talked about, because I have shortlisted 5 important judgments for you. If you haven't checked that video, kindly go and check it out. The previous video section, you will get it. 5 most important video for your CLAT PG. ठीक है, उसमें मैं ऑलरेडी एक क्लास में मतलब प्रीवियस क्लासेस में एक पर्टिकुलर केस को डिस्कस कर चुका हूं इन डिटेल. दैट इज अलीगढ़ मुस्लिम यूनिवर्सिटी केस. अगर वो वीडियो आप देखे नहीं हो तो जाके देख सकते हो. आज के वीडियो में हम लोग बात करेंगे इस पर्टिकुलर केस के बारे में, सेकेंड पार्ट, स्टेट ऑफ तमिलनाडु वर्सेस गवर्नर ऑफ तमिलनाडु. ठीक है, now ये केस बहुत ही इंपॉर्टेंट है for your CLAT PG purpose, and it's one of the recent ones that you need to remember. Okay, now this case, state of Tamil Nadu versus governor of Tamil Nadu, that we are going to talk about today. Okay, I'm going to share the judgment with you and I'm going to share the details. But उससे पहले मैं थोड़ा brief करूंगा पिछले क्लास में हम लोग क्या पढ़े थे. ठीक है, so that will help you to understand. And then उसके बाद हम लोग इस केस के डिटेल में जाएंगे एक एक करके और समझेंगे. ठीक है, नाउ एज दिस पर्टिकुलर केस इज ऑल अबाउट आर्टिकल 200 एंड इंटरप्रिटेशन ऑफ आर्टिकल 200 इन डिटेल. ठीक है, सो द फैक्चुअल मैट्रिक्स ऑफ द केस वाज वेरी सिंपल. फैक्चुअल मैट्रिक्स ऑफ दिस केस वाज ऑल अबाउट the bills that were sent for governor's assent that were not done by the governor, and then ultimately that led to this particular case. ठीक है, मैं आप लोगों के साथ पहले judgment share करूंगा. I'm going to share the judgment. I'll show it to you. Okay, then I'll get to the issue part, and then I'll get to the other aspect of the judgment. ठीक है, एक एक करके. So पहले मैं आप लोगों के साथ जो share करूंगा that is the issue. ठीक है, एक सेकंड. and the factual metrics briefing. I'm going to brief you the factual metrics. 1 second. Okay. So in the previous class, I have talked about this particular judgment. I hope you're able to see it on the screen. I have shared it. Okay. This particular judgment, Justice Pardiwala has authored this judgment, State of Tamil Nadu versus Governor of Tamil Nadu. It's actually a very lengthy judgment. Around 450 pages of judgment has been authored by this judge. Okay, and we have to go through this judgment. We have learned the factual metrics. To give you a briefing of the factual metrics, जो factual metrics में अगर मैं brief करूं तो उसके बारे में मैं ये बोला था, स्टेट ऑफ तमिलनाडु में एक सिचुएशन क्रिएट हुआ था जहां पर बेसिकली तमिलनाडु के गवर्नमेंट 12 bills they passed by the state legislature and after that they send it to governor for governor assent. क्योंकि आप लोगों को पता है आर्टिकल 200 के अंदर गवर्नर का एसेंट चाहिए होता है एक बिल को एक्ट बनाने के लिए. नाउ प्रॉब्लम क्या हुआ, ठीक है, ये सिचुएशन वाज हैपनिंग बिटवीन 2020 टिल 2023. इन दैट पीरियड 3 years तक. तो पहले एक साल तक गवर्नर के ऑफिस में जो पहले का गवर्नर था, दैट इज नॉट द इशू, the part of this particular situation. The new governor joined in the year around 2021 के last part of the 2021. I've talked about in detail in the previous class. आप उस क्लास में भी मैं factual matters के बारे में बात किया हूं, ठीक है. जब उन्होंने ज्वाइन किया, ठीक है, उसके बाद the 12 bills that were sent for governor assent that were pending, ठीक है. उसके बाद भी 2021 से लेकर 2023 तक that new governor did not take any action at all on the pending bills, 12 bills. जब 2023 में the state legislature approached the Supreme Court to take the help. Supreme Court basically given the direction in that case, or court given the direction to take the matter as soon as possible. Okay. And with that instruction, governor took the decision on that 12 bills. 12 बिल में से 2 बिल गवर्नर प्रेसिडेंट एसेंट के लिए सेंड कर चुके, 10 बिल को गवर्नर विथहेल्ड कर दिए, ठीक है, बट डिड नॉट सेंड इट बैक टू लेजिस्लेचर. उसके बाद गवर्नर से रिजेक्ट होने के बाद बिल, स्टेट लेजिस्लेचर और स्टेट गवर्नमेंट सोचे कि इस बिल को दोबारा पास करना पड़ेगा, ठीक है, क्योंकि गवर्नर रिजेक्टेड इट. ऐसे ही स्टेट लेजिस्लेचर बेसिकली पास दैट बिल अगेन in the state legislature, send it back to governor. When it is send it back to governor उस टाइम उस 10 बिल को प्रेसिडेंशियल रिकंसिडरेशन के लिए सेंड करते. अब चीफ मिनिस्टर रेज्ड फ्यू क्वेश्चंस रिगार्डिंग दैट, क्योंकि आर्टिकल 200 के अंदर जो हम लोग पिछले क्लास में पढ़े थे, अंडर आर्टिकल 200 वन वेरी इंपॉर्टेंट थिंग दैट इज देयर. अंडर आर्टिकल 200 if you see it, under the first proviso, if the bill is sent to governor second time, governor has to give its assent. Governor के पास कोई choice नहीं होता है. But here in this case, governor ने क्या किया, second time जब उसको bill send किया गया, governor send it for presidential reconsideration. चीफ मिनिस्टर ने ये रेज किया कि कैसे हो सकता है कि गवर्नर कैन सेंड इट टू प्रेसिडेंशियल रिकंसिडरेशन इन दिस सिचुएशन, क्योंकि गवर्नर को एज पर द प्रोवाइसो 1 ही हैज टू असेंट टू द बिल, ही कांट सेंड इट फॉर प्रेसिडेंशियल रिकंसिडरेशन द सेकंड टाइम. दूसरे और एक चीज है, गवर्नर के साइड से रिस्पांस था कि आई डिड नॉट रिटर्न द बिल टू द स्टेट लेजिस्लेचर. तो आप अगर प्रोवाइसो 1 पढ़ोगे, इफ द बिल इज सेंट or return it to legislature, then the legislature repass the bill, send it back to governor, then governor has to give the assent. Governor का ये कहना था, governor is saying I rejected the bill, I did not send the bill to legislature, I only rejected. What it means कि उन्होंने बिल को दोबारा सेंड नहीं किया. दोबारा ना मतलब सेंड नहीं किया रिजेक्शन के बाद. So for the governor side is saying when the second time the bill presented to him, he is treating it as a first time. ठीक है, समझना इस चीज को, कंफ्यूज मत होना, इस चीज को समझना. अगर ये आपको कुछ भी क्वेरी हो, गिव मी मैसेज और कमेंट करो उसमें, ठीक है. तो गवर्नर का कहना था कि मेरे पास जो बिल दूसरी बार आया, क्योंकि मैं पहली बार रिजेक्ट किया था, मैं रिटर्न नहीं किया था, ठीक है. सो सेकेंड टाइम व्हेन दोस बिल प्रेजेंटेड टू मी, I thought it is presented for the first time, क्योंकि मैं पहली बार पूरा ही रिजेक्ट कर दिया, दूसरी बार जो आया प्रेजेंट हुआ है मेरे सामने, दैट इज टोटली अ फ्रेश न्यू बिल, आई ट्रीटेड दोज बिल्स एज न्यू बिल्स, तो इसीलिए मैं उसको प्रेसिडेंशियल रिकंसिडरेशन के लिए सेंड कर दिया। बट यहां पर क्वेश्चन अराइज होता है अंडर आर्टिकल 200, क्या गवर्नर एक बिल को सिर्फ रिजेक्ट कर सकता है? कैन ए गवर्नर only reject the bill without sending the bill to the legislature? Can he do that? Or whenever governor withheld a bill or reject a bill, he has to send it back to legislature? Both the action needed to be done cumulatively or separately. Now here from the governor side, governor said, I have done only rejection, no returning back. Chief Minister is saying, you can't do that under Article 200 because Article 200, when you withhold the assent, you have to send it back to legislature. And we thought after repassing, you have to give the assent. That is one of the very important questions that has arisen in this case. So you are very well understanding here, governor क्या कर सकता है क्या नहीं कर सकता, what governor can do or cannot do, that is one of the main point of contention that is arising. But sir, क्या बोलना चाह रहे हो आप? What I'm trying to say, what is the possible courses of action for governor to take under this 200 article 200? Possible course of action मतलब governor क्या क्या कर सकता है? Can governor sit on the bills? Pocket veto है governor के पास, क्योंकि governor in this instance to 2021 से लेके 2023 तक कुछ response ही नहीं किया, did not take any action. So if you knew, I talked about in the first class what I talked about the pocket veto, ठीक है? पॉकेट वेटो के बारे में जब मैं आप लोगों को बात किया था, पॉकेट वेटो मींस व्हेन, दो आई टॉक्ड अबाउट रिगार्डिंग द प्रेसिडेंट, बट पॉकेट वेटो मींस व्हेन गवर्नर डिड नॉट टेक एनी एक्शन, not taking any action, not taking any action. So first from 2021 to 2023 तक governor did not take any action at all. Can governor do that? First thing. दूसरा, governor rejected the bill or withheld the bill, rejected the bill or withheld the bill. Rejected the bill means absolute veto, absolute veto. So can governor absolutely veto a bill, rejected the bill, ठीक है? और governor has to after withheld send it back to legislature, send it back to legislature, send it back to legislature. Okay. So the thing is that if you are very well understanding the point of contention that is arising here, कि गवर्नर के पास सर क्या क्या चीज गवर्नर कर सकता है आर्टिकल 200 के अंदर? क्या गवर्नर के पास पॉकेट वेटो है? कैन गवर्नर सिट ऑन द बिल्स फॉर 2 years 3 years? मतलब आप लेजिस्लेचर हो, सपोज आप चीफ मिनिस्टर हो, आप एक बिल को पास किए एंड उस बिल को पास करने के बाद आप उसको सेंड कर दे गवर्नर को। अब गवर्नर 2 साल 3 साल से बैठे हुए हैं, आपका गवर्नमेंट चला गया, वो बिल बना ही नहीं। कैन गवर्नर डू दैट? वो बिल एक्ट ही नहीं बना कभी। दूसरा, कैन गवर्नर रिजेक्ट द बिल विदाउट सेंडिंग द बिल टू लेजिस्लेचर? In this case, what governor of the Tamil Nadu state is claiming that he has rejected, can he do that under Article 200? If he can do that, under what ground? Is there any mention under Article 200 subjective part? ठीक है? Or governor when withheld the bill, he has to send it back to legislature. So how he can do that in that case? Okay. So here, if you see it, all the scenario basically. 1 second. So one of the very important thing, if you understand, okay, let me share the screen again. So can governor do the things here in this particular instances? Okay. So what are the things I was talking about? What is the probable course of action that governor needs to take? Okay. So if Article 200 में देखोगे, so the first issue, what is the courses of action? So if you check the first issue itself, मैं आप लोगों को first issue दिखाता हूं, you will be able to see that what is the first issue all about. Okay. Analysis. First issue है what courses of action are available to governor in the exercise of his powers under Article 200 of the Constitution. Courses of action मतलब अभी मैं आप लोगों को दोबारा समझाता हूँ, ठीक है? Courses of action मतलब whatever we are talking about. Prima facie under Article 200, the three courses of action are visible. I was talking about in the previous class. Prima facie, three courses of action. Three courses of action क्या क्या है? The first is assent to the bill. Second, withhold the bill. Send it for presidential reconsideration. These are the three courses of action that are available to governor prima facie. Now, अगर आप जनरली इसको पढ़ोगे आर्टिकल 200 को, आप बोलोगे सर तीन ही तो है, इसमें ज्यादा कुछ है नहीं, दैट ओनली थ्री थिंग्स. बट इफ यू रीड एनी रेफरेंस बुक, जैसे आप बीएन शुक्ला पढ़ोगे, वहां पर फोर्थ कोर्स ऑफ एक्शन बताया जाता है, ठीक है? दैट इज एक विथहोल्ड और एक सेंड इट बैक टू लेजिस्लेचर, और एक कोर्स ऑफ एक्शन के बारे में रिटर्निंग टू लेजिस्लेचर, ठीक है? मेरे पास जिस एडिशन का बीएन शुक्ला, आई डोंट नो इट हैज दे हैव चेंज्ड इट और नॉट, बिकॉज़ आल्सो द वेगनेस दैट इज एक्जिस्टिंग इन आर्टिकल 200 was huge, and that's why this case is there, because article 200 के regarding सारे गवर्नर थ्रू आउट इंडिया दे आर मिसयूजिंग दिस पर्टिकुलर पार्ट. वेस्ट बंगाल में बात करूं, वेस्ट बंगाल में यूज हो रहा है. स्टेट ऑफ तमिलनाडु, दे आर मिसयूजिंग, गवर्नर ऑफ द स्टेट इज मिसयूजिंग दिस आर्टिकल 200. एंड व्हाई दे आर मिसयूजिंग, मैं आपको बताता हूं. अगर आपको पता चलेगा, इफ द मेजर और रूलिंग पार्टी जो सेंटर में है बीजेपी, शायद उसके गवर्नर और उसके गवर्नर बोल रहा हूं, उस पॉलिटिकल पार्टी के वो स्टेट में अगर बीजेपी रूल नहीं कर रहा है, मोस्ट ऑफ द केसेस अगर जहां पर नहीं है, तो इन दैट केसेस इफ द गवर्नर इज फ्रॉम another political party or the ruling party BJP से है, so there is a conflict. Whatever the state, the chief minister is trying to do, governor is trying to do another thing. So chief minister sending and passing the bill, legislature से send करके governor को send कर रहा है, governor is not doing anything. Governor दूसरे पार्टी के political affiliations, so this particular office is absolutely neutral, but कहीं ना कहीं कुछ political affiliations के चलते governor is not taking any action, trying to delay the process, and that's why Article 200 has been misused for so many years. इसीलिए सुप्रीम कोर्ट को इंटरवेन करना पड़ा इस पर्टिकुलर आर्टिकल 200 के मैटर में, ठीक है? सो द मोस्ट इंपॉर्टेंट थिंग इज दैट द courses of action, three courses of action, and then fourth courses of action is written into the legislature. Many of the books also suggesting that, reference book. But is there any fourth or the second or third? It is actually combined. If he withheld, it has to return to the legislature. He does not have any other way. That is the main issue that is talked about. ठीक है? I hope you understood the issue. Any query as of now? Type in the chat box. Any query? Any query that you want to ask? Type in the chat box. Any query that you want to ask? Type in the chat box. Okay. Let me see. Do you have any query or not? Okay. मैं एक बार देख लेता हूँ. कुछ query है? कुछ query है? Nothing. So I am going to गेट इनटू द नेक्स्ट पार्ट ऑफ इट. ठीक है, मैं इसके नेक्स्ट पार्ट में जाऊंगा और उसको डिस्कस करूंगा फर्दर. ठीक है, सो हम लोग इस चीज को और भी डिस्कस करेंगे, एंड हाउ वी गोइंग टू डिस्कस इट, वी गोइंग टू डिस्कस इट इन डिफरेंट वे. ओके, एक सेकेंड. Now, assenting to the bill we have learned. Okay, now we are going to get to the next part. अभी जो इशू हम लोग बात किए ना, the issue that we talked about in detail, that issue is regarding what are the courses of action. Now, regarding the courses of action, if I take you to the judgment itself, I hope you're able to see the judgment itself. Okay, तो मैं judgment में जाऊंगा. ठीक है, इसमें the few things that I am going to tell it to you. Okay, so the first thing, Attorney General here, Attorney General, in the support of the governor, what he has talked about. Attorney General is saying, in the support of governor, that there are four courses of action that is available to governor under Article 200. Four. ओके सर, क्या क्या है? अटॉर्नी जनरल बोल रहे हैं कि 4 कोर्सेज ऑफ एक्शन है। एक एसेंट, सेकेंड withhold simpliciter, it means only rejection. Third, return the bill to legislature. Fourth, send it for presidential reconsideration. This is the fourth. Attorney General is claiming that there are 4 courses of action and governor has taken the second option. Withhold simpliciter. He basically rejected it. He did not send it back to the legislature. His claim is coming from 3 very important judgment. 3 important judgment उसके पार्ट से आ रहा है, ठीक है? और उसका मेन जो पार्ट है वो है वल्लूरी चौधरी केस. ओके, now the Valluri Chaudhary case has been referred here in relation to this particular situation. Attorney General referred Valluri Chaudhary case, and in this particular case I'll show you the portion from which Attorney General is taking the substance from. ठीक है? Now I'll show it to you first. मैं आप लोगों को दिखाता हूं. Attorney General is basically saying, as per Valluri Chaudhary, okay, देखो, para 179, Valluri वसभैया चौधरी, I might not pronounce it correctly, ठीक है? आप लोग शायद मेरे से better pronounce कर सकते हो. So if you see it on the screen here in this particular situation, okay, अगर आप screen देखोगे, while Attorney General putting his contention on the basis of this particular argument. So वल्लूरी चौधरी में जब डिस्कशन चल रहा था आर्टिकल 200 के बारे में, the Supreme Court mentioned the governor can adopt 3 courses. Okay. One course, he may give his assent to the bill in which bill becomes law. Second, he may accept in case of money bill छोड़ देता हूं मैं, withhold his assent therefrom, in which case the bill falls through unless the procedure indicated in the first proviso is followed, return the bill to the assembly for reconsideration with a message. So what he is claiming in this case, that very important, Attorney General took this part separately. Look at this. It's a very interesting and subtle part. You have to understand. Attorney General basically showing it in the Valluri Chaudhary that withhold assent therefrom, in which case the bill falls through. Okay. Withhold his assent therefrom, in which case bills fall through. So what Attorney General is saying कि देखिए, गवर्नर के पास ना 4 ऑप्शन ही है, 3 ऑप्शन नहीं है, 4 ऑप्शन. क्यों? क्योंकि सुप्रीम कोर्ट जब इस वल्लूरी चौधरी में बात किया है, इसमें बोला गया है कि अगर गवर्नर, if governor withheld his assent, in that case the bill will fall through. So it means if he rejects outrightly or withhold simpliciter, जो बहुत बार इस जगह में यूज किया गया है, if he withheld simpliciter, in that case bill will fall through. Now the most important thing, if you can understand, okay, that if you can understand, okay, so the most important part, that Attorney General reading it separately from the next part, that is unless the procedure indicated in the first proviso is followed. So he's saying there are two processes to it. One, not giving the assent. Second, returning bill to the procedure. So Attorney General focused his argument based on that, and via that he is deducing that there is a separate procedure if governor did not give assent itself or rejected the bill. Based on that, Justice Pardiwala, while going through Valluri Chaudhary, the argument from Attorney General, he saw that Valluri Chaudhary is not the first case this particular thing is mentioned. He saw Justice Pardiwala writing down that there are few other judgments which talked about on the similar line, like State of Bihar versus Maharajadhiraj Sir Kameswar Singh of Darbhanga. In that particular case, same line has been talked about. 3 courses of action. If he may declare that he withholds the assent therefrom, in which case the bills fall through unless the procedure indicated the proviso. Same line from which this Valluri Chaudhary has been taken. Second, Hoist Chemicals is another particular 3 judge bench. In that case also, Hoist Chemicals case, same line has been mentioned. So, Justice Pardiwala is saying the Valluri Chaudhary, the reference that has been taken by Attorney General, this particular part has been talked about again and again in other 2 judgments. So the main contention what Attorney General is raising here, whether there is another course of action on the part of governor that to withhold the assent that is existing or not, that is the answer to be given by the Justice Pardiwala. And to give the answer of this particular question, what Attorney General is putting forward, इस मामले में Justice Pardiwala took the recourse of his own judgment that he has authored in the year 2023-2024, that is State of Punjab versus Principal Secretary of the Governor. उसके बारे में हम लोग बात करेंगे, ठीक है? तो Justice Pardiwala, to support his claim कि no, there are only 3 courses of action, not 4. इसके लिए Justice Pardiwala took the recourse of that State of Punjab versus Principal Secretary of Governor, that particular case, and side by side how he interpreted this Valluri Chaudhary statement again in new way, ठीक है? उसको better way में कैसे interpret करना था, उनको interpret किए. तो पहले हम लोग State of Punjab देखेंगे, then उसका interpretation देखेंगे Valluri Chaudhary and Kameswar Singh and this Hoist Chemicals के जो line Attorney General जिसके ऊपर बेस करके claim कर रहे हैं कि there are 4 courses of action for governor, उसके बारे में बात करेंगे, ठीक है? I hope you are understanding. Any query, whatever I am talking to you, any query regarding this thing? Any query regarding this thing? Are you understanding? Understanding? Okay. So I'll take you to the State of Punjab versus Governor of Punjab or Principal Secretary of Governor. Now that case is also very important. It's a reference case for the courses of action. Justice Pardiwala took the recourse of that particular judgment. उस हिसाब से Justice Pardiwala is going to give the answer. ठीक है? Now, Pardiwala, when talked about this particular aspect, okay, उस केस में भी, Principal Secretary case में भी, he was in the bench, but Justice D.Y. Chandrachud has given the judgment. Okay. So if you see it, D.Y. Chandrachud has authored the judgment. It's a very small judgment, by the way. Okay. I'll help you go through the facts of the case. Okay. And then we'll get to the main part of the particular judgment. That's very, very important. Okay. That Justice Pardiwala took the recourse here. Okay. So I hope you understood. So we are talking about the course of action. We are talking about whether there are 3 courses of action or more than 3 courses of action on Article 200. And Attorney General put forward by definition, by the interpretation of Valluri Chaudhary, that there are 4 courses of action. Okay. And various reference law book also talk about there are 4 courses of action, by the way. So whether 3 or 4 courses of action, that is very important. Now, any query you can mention in the comment box as of now. ठीक है? मैं थोड़ा देख लेता हूँ. Do you have any comment or not as of now? Then I'll move forward. Okay. I'll move forward. Okay. So now the most important thing which I'm going to talk about, is the next part. Principal Secretary of Governor, State of Punjab, this particular case. Justice Pardiwala relied on this particular judgment, his own judgment, to give this judgment. ठीक है, इस जजमेंट के ऊपर रिलाई किया. स्टेट ऑफ पंजाब वर्सेस प्रिंसिपल सेक्रेटरी ऑफ गवर्नर. तो एक जजमेंट को पढ़ने के लिए दूसरे जजमेंट भी हम लोगों को पढ़ना पड़ता है, और बहुत डिटेल में. So what you have to learn here in this case, ठीक है. Now the most important thing in this particular case, it is on the similar line. The factual background of this case, State of Punjab is the Principal Secretary of the Governor of Punjab. Here, Governor tried to do many things. Okay, quite. So here in this particular situation, Governor of Punjab did not want to summon the budget session. So generally, Governor is going to call for the budget session, but he does not want to call for the budget session. Why? Because he thought, okay, there is no occasion to. He wants to seek some kind of legal advice, and then after that he is going to call for budget session. आप बोलोगे सर इसमें लीगल एडवाइस सीख करने की क्या बात है? एज पर कॉन्स्टिट्यूशन मैंडेट गवर्नर को तो बजट सेशन बुलाना चाहिए ना सर. बोला हाँ सही है, बट गवर्नर को लीगल एडवाइस चाहिए था. क्यों? वो पंजाब के गवर्नर ही बता सकते थे क्यों. चीफ मिनिस्टर एंड ही डिड नॉट समन. चीफ मिनिस्टर अप्रोच द कोर्ट एंड कोर्ट सेड गवर्नर जी अब जितना जल्दी हो सके बजट सेशन बुला लीजिए. दैट्स वन ऑफ द कॉन्स्टिट्यूशनल मैंडेट. ओके. Governor then, after the court's instruction, called for budget session. Budget session में there are few bills that have been presented, okay, to governor after being passed by the legislature. तो legislature ने कुछ bill pass किए, ठीक है. So around 4 bills have been passed, okay, by the legislature. And देखो, Sikh Gurudwaras bill, Punjab affiliated colleges bill, Punjab University, Punjab Police, all those bills have been passed. But whenever it is presented to the governor did not take any action. ठीक है. तो गवर्नर कुछ बोले नहीं. उसके बाद फिर रिकन्वेन किया गया विधानसभा सेशन को. Another 3 bills were there. ठीक है. So total 7 bills. Now what happened? Governor did not take any call on these 7 bills all of a sudden. And he said, we want to take, or governor wants to take legal advice, and all the 7 bills that were passed during this session, all are flawed. Okay. All are flawed, and all are suffering from constitutional invalidity. Now, the state of Punjab approached the court why these bills were not given by the assent given by the governor, and where there is a breach of law and procedure in this particular situation. That's why this case we are talking about. इसीलिए हम लोग इस केस के बारे में बात कर रहे हैं. Now ये केस का सबसे another important part जो आ रहा है, ठीक है, वो है कि इस केस में DY Chandrachud authored the judgment. While authoring the judgment, DY Chandrachud, this Pardiwala was also in the bench, but actual author of the judgment was DY Chandrachud. Now, DY Chandrachud, while authoring the judgment, mentioned few very important things. Okay, mentioned very few important things. He said the courses of action for a governor in this particular case, simultaneously why governor and what are the possible courses of action and what is the power. ठीक है. अगर आप आर्टिकल 200 को देखोगे, आर्टिकल 200 में with a prima facie you will get to understand it's a conflict of power between two parties, one the governor and another one that is the chief minister. Now, the conflict of power, who has the more power, the state legislature or the executive or the governor, who has the more power? That is the main problem here we are talking about. Now, as these things were talked about, Justice Pardiwala entered into this particular judgment and tried to find out some important point that I am going to show it to you. So first state DY चंद्रचूड़ इस केस में क्या मेंशन किए वो मैं पहले बताता हूं, ठीक है, and then I'll go back to the state of Tamil Nadu versus Governor of Tamil Nadu. So state of Punjab में DY Chandrachud mentioned few things. Okay, he interpreted, DY Chandrachud interpreted Article 200. So first he interpreted this particular word shall declare. Then he interpreted the Article 200 subjective part, means this subjective part, and what is the possible course of action. Now, first thing he stated, and this is the crux, okay. D.Y. Chandrachud stated that the difference here between power that is given to a symbolic head and the power given to a direct representative of the democracy. Sir, मतलब क्या बोल रहे हो आप? Symbolic head and direct representatives. Symbolic head मतलब if you know governor is elected indirectly. Governor is elected indirectly मतलब governor is basically that titular head of the state. Okay? Whereas the direct representatives, the member of the state legislature, they were directly held. Now, who has more power? Who has more power? Can governor who has been elected indirectly have so much power to stop the process of direct elected representative start? ऐसी कोई प्रोसेस और लेजिस्लेशन क्या एक सिंबॉलिक हेड स्टॉप कर सकता है या विन कर सकता है? इज देयर एनी काइंड ऑफ पावर गिवन टू अ गवर्नर अंडर आर्टिकल 200 और नॉट? ठीक है. नाउ इन दैट केस, from the very first instance you are able to understand symbolic head and direct representatives. So D.Y. Chandrachud is mentioned in this state of Punjab case कि देखिए गवर्नर इज a symbolic head और गवर्नर का काम ये है to become the friend philosopher guide of the state legislature or the state itself. So how can he become a friend philosopher and guide in relation to state legislature? By supporting the bill or reviewing the bill or changes, any necessary changes that needed to be made in the bill, what has been presented to him. But here in this situation, in Punjab case or even in Tamil Nadu case, if you get to see, governor by the power of pocket veto or absolute veto, they are rejecting the whole process of direct representatives. Okay, but sir, matlab when you, me are selecting or electing the direct representatives, मतलब हम लोग जब वोट देके किसी को इलेक्ट करते हैं, in that situation we chose that particular person or group of person to run the government. And to run the government, legislature is one of the main important tool. एक parliamentary democracy में legislature और legislation बनाना, pass करना बहुत important है. So you and me are choosing group of person who are going to legislate on behalf for our own betterment, right? For our own betterment. That's why they are there. But governor is a symbolic head whose work is just to be friend philosopher guide to state legislature. And in some of the situation, Article 163 talks about that some discretionary power is also given to governor. Under Article 163, most of the time, governor is going to act with the aid and advice. And in other situation, few other situation, governor has the discretionary power. But in assenting to the bill, governor being a symbolic head, if he is given that much power for absolute veto or pocket veto, there is a possibility that governor is going to stop the legislating process itself. Kyunki if you think it, direct representatives or the legislature, state legislature passing the bill, send it back to governor. अब governor के पास absolute veto है, pocket veto है. अब when governor has the absolute veto, pocket veto में not taking any action, 2 साल 3 साल कोई legislature assent ही नहीं दिया, कोई bill ही नहीं बना, bill नहीं बना, 3 साल 4 साल 5 साल government change हो गया. And you understand why bill is one of the very important, the enactment legislation is one very important part of governance. डेमोक्रेसी का एक बहुत इंपॉर्टेंट पार्ट है. दैट पार्ट इज entrusted with the direct representatives, but an indirect or symbolic head, if he is entrusted with that discretionary power under Article 200, there is a possibility of ruining the whole process or manipulating the whole legislative process of the state altogether. What is happening in relation to Punjab and state of Tamil Nadu here? I hope you are able to understand whatever I am trying to tell you. Okay. So here, this is D.Y. Chandraju saying कि आप एक symbolic head को discretion power under Article 200 में कैसे possible है? If it is given, so the whole legislative process is going to get ruined. It is not possible. So the part is that governor only is going to play the role of reviewer and see the things and give the assent. That's it. That's it. That is the part that governor is there. So symbolic head versus direct representatives. That is the very good reasoning, very, very good reasoning that has been given by direct representatives. Symbolic head versus direct representatives. Okay. Now, this very important part, D.Y. Chandrachud mentioned in the Punjab case. Okay. Now, in the Punjab case, another thing D.Y. Chandrachud mentioned, that is the word shall declare. Okay. Word shall declare. Now, many of you, if I ask you, what is the meaning of shall? If there is shall before a verb, what does it mean? And many of you are going to tell me, sir, shall means it has to be done. It is mandatory in that case. So here, governor need to declare the assent or withhold the assent therefrom. Okay. And reserve the bill for consideration. The 3 part. Okay. In the first proviso, if you see it, this shall is changed to may. But sir, kyun? Okay. And the word as soon as possible. Both the cases. These 2 words, D.Y. Chandrachud focused on in state of Punjab. May and as soon as possible. So D.Y. Chandrachud said in state of Punjab, the word may is basically when there is an option. So here in this situation, governor has option whether to give the assent or whether is withhold. If governor withholds, in that case he return the bill with a message that House will reconsider the bill with inclusion of that message or without that message and returned it after repassing by the legislature. Simple. Okay. So having said that, the most important part needed to be done here is nothing but you are understanding as soon as possible. It means जब bill present किया गया, आपको तुरंत कोई ना कोई call लेना है. You can't really wait for it. And second, the discretion, the course of action that is there is only assenting to the bill, withhold the assent therefrom, and reserve the bill for consideration. These 3 options are there. Not more, not less. 3 options. Okay. So D.Y. Chandrachud, while saying what for the Punjab governor has done, he basically laid down the information in that case. ठीक है, मैं दोबारा आपको पंजाब वाला जजमेंट दिखा देता हूं. You'll be able to recall, but most of the things I have shared with you. ठीक है. So this is the Punjab wala judgment. Okay. Governor is a symbolic head, cannot withhold the action on bills passed by state legislature. So अगर मैं आपको पहले एक दो लाइन दिखाऊं, in a parliamentary form of democracy, real power vests with the elected representatives. Government both in the state and the center consists of member of state legislature and parliament. Members of the government in a cabinet form of government are accountable to, subject to the scrutiny by the legislature. Governor as an appointee of the president is titular head of the state. Fundamental principle of the constitutional law, which has been consistently followed since the constitution was adopted, is that governor acts on the aid and advice of the council of ministers. Under article 163, that aid and advice that is mentioned, a governor aid and advice से काम करेगा. Other than that, there are certain discretionary power. But the thing is that, is there any discretionary power is given under Article 200? But the question is, if the discretionary power is given, absolute and this thing, absolute power or absolute veto or pocket veto, then this kind of situation is happening. The discretionary power that is given under Article 200, that is in only in the second proviso, where if I show it to you, governor shall not assent to but shall reserve the consideration of the president any bill which in the opinion of the governor. Here in subjective part or in the proviso 1, no discretion has been given to president. Only in the second proviso the president discretion has been given and only given. So under Article 63, as it has mentioned, governor has to act with the aid and advice of the chief minister. Governor has to act. अगर कोई bill present किया गया है, in most of the cases, governor has to act with the aid and advice of the chief minister and the council of ministers, and he has to give assent or withhold the assent, send it back to legislature for repassing. If the bill is passed after proviso 1, send it back to governor. Governor is going to assent. कोई ऑप्शन नहीं है गवर्नर के पास, कोई ऑप्शन नहीं है. Only discretion is given in the second proviso, which we're going to talk about in the coming issue में हम लोग इसको डिटेल में बात करेंगे. But as of now, this is the part to be talked about. ठीक है? I hope you understand any query that you have under this particular case. This case is important, guys. If you don't get to this particular case, it's very very important. आप पुराने वाले वीडियो दोबारा देखो, फिर दोबारा ये वाला वीडियो देखना recorded में भी, you will get to understand this case. This case is more interpretational and so many other cases to be referred for this thing. ठीक है, आपको बहुत सारा चीज देखना पड़ेगा. If you have any query, do let me know. अभी मैं उसके बाद नेक्स्ट पार्ट में जाऊंगा. ठीक है, एक सेकेंड. Okay, so we are going to talk about the next part of this particular judgment. Okay, the next part of the particular judgment will be very very important. Okay, I got a question that CLAT क्या होता है सर? CLAT तो I'll talk about the CLAT at the last part regarding this thing. ठीक है, मैं CLAT के बारे में बात करूंगा, बट पहले मैं केस के जो पोर्शन आज मैं कंप्लीट करने वाला हूं उसके बारे में बात कर लेता हूं. उसके बाद मैं CLAT के बारे में बात करूंगा. I'll definitely talk about CLAT PG. ठीक है. And also there are so many videos that are available on this channel that talks about CLAT PG. आप वो वीडियो को भी रेफर कर सकते हो, but I'll talk about it. Okay, just wait for a moment. I'll talk about it. Please let me complete the portion that I want to complete first. Okay. Okay. Now the next part, which will be very very important for all of you to go through, and which I'm going to share right now. Okay. Which is the Justice Pardiwala's understanding. So Justice Pardiwala took the recourse of D.Y. Chandrachud State of Punjab case. He also stated that कि देखिए symbolic head and titular head cannot basically hamper a democratic process of legislation. ठीक है, नहीं कर सकते हैं. So discretionary power is there, but discretionary power is very limited under Article 200. That is regarding the proviso, second proviso only, which we're going to talk about. But other than that, in proviso 1 and the subjective part, Article 200 has to be, governor has to act within the aid and advice of the council of ministers and chief minister. Okay, that what has been talked about. Now, having said that, coming to the next very important part, how Justice Pardiwala negated the three important judgments तेरे वल्लूरी चौधरी जो मैं पहले आपको दिखा रहा था, और कामेश्वर सिंह और हॉइस्ट केमिकल्स, जो लाइन जस्टिस पर्दीवाला उसको कैसे रेफर किए, ठीक है, उसके बारे में मैं बात करूंगा. सो जस्टिस पर्दीवाला, हाउ ही टॉक्ड अबाउट दिस पर्टिकुलर थिंग, ओके, except in the case of money bills in which the bills fall through. So here, this is Pardiwala referred very important thing, ठीक है, and said very important thing जिसके बारे में मैं बात करूंगा. Attorney General basically read, while reading these three cases, that the bill will fall through if the governor withholds his assent. In that case, okay, Attorney General stated that there is another course of action available. But Justice Pardiwala is saying कि देखिए, ये जो लाइन है, it has to be read comprehensively and wholly or completely. You can't read the line separately and deduce a separate meaning. मतलब क्या? मतलब ये है, Attorney General reading the line from here to here and then here to this. So Justice Pardiwala is saying he withholds the assent therefrom, in which case the bill falls through unless the procedure indicated in the proviso is followed. It means it is very simple. If you know the procedure, that is, a bill passed by the legislature, sent it to the governor. Now governor is going to either give the assent, three option है governor के पास, assent, withhold and return, withhold, and another is reconsideration. Okay, for presidential reconsideration. Okay, presidential reconsideration, send it for president. These are the situation. Now here in this case, when the governor press the withhold button, मतलब एक बिल को अगर withhold करती है गवर्नर, assent नहीं दे, withhold करती है, in that case the bill will be sent to the legislature. Bill will be sent to the legislature. This is Pardiwala saying when it is withheld, it is returned to the legislature. Withheld and returned to the legislature simultaneously, it is happening. And in the legislature, the state legislature is going to again repass the bill. Now, there is a procedure or there is a process when the bill is withheld and returned to the legislature, state legislature might not repass the bill again. उसमें कोई चेंजेस के बारे में जो गवर्नर ने बोला, वो गवर्नर उस चेंजेस को लेके, or with the amendment or without the amendment, with whatever might be the case, state legislature did not pass the bill again. In that case, if the process is not followed, the bill is going to fall through. As simple as that, right? So if the bill is going to fall through, that part is being talked about here. The Justice Pardiwala is saying what Attorney General is trying to put forth, only rejection will make the bill fall through. No, not really. Rejection of the governor will not make the bill fall through. Rejection and returning the bill, and in the return, when the bill, the proviso 1 procedure, that means bill is not repassed again by legislature. Bill is not repassed again by the legislature. If that is not done, in that case, the bill will fall through. So proviso 1, if that process is not complete, then only the bill will fall through. Rejection से fall through नहीं करेगा. This is Pardiwala saying the bill will fall through when the procedure in the proviso 1 is not followed, that is when the bill is returned, send it back to legislature, legislature did not pass the bill second time, ऐसा भी तो हो सकता है. That time the bill is not followed or the bill falls through because the procedure is not followed. That's how just Partiwala negated the concept of this particular situation. Okay. Did you understand? Any query? Type in the comment box. Any query? Did you understand? Okay. So, not rejection. Rejection, return, and it's upon the legislature. So, Justice Pardiwala is saying, governor is not a very important mechanism in relation to passing the bill. Governor's assent is very important to make the bill an act, but legislature is always holding the key and the power to pass the bill. That is, पहले बिल पास किए, गवर्नर के पास सेंड किया, गवर्नर विथ होल्ड किया, रिटर्न कर दिया, कुछ चेंजेस करना है, विद दैट चेंजेस बिल दोबारा लेजिस्लेचर के पास आया, दैट लेजिस्लेचर इज गोइंग टू रिकंसीडर द चेंजेस, डिड नॉट कंसीडर द चेंजेस, अगेन रीपास द बिल and send it back to governor. Governor is going to give the assent. As simple as that. But if when the second time it is sent to the legislature, if the legislature did not pass the bill will fall through. In that situation, governor के assent के लिए bill fall through नहीं कर रहा है. ठीक है? So this is the very important part needed to be understood in this situation. Okay? That what he has given. Any query regarding this thing, do let me know in the comment box. Any query regarding this thing. Okay, I'll just check any question kuch aaya hai ya nahi. Any query? Okay, now the most important part here, the most important part here needed to be understood here in this case. Okay, this courses of action that I was talking about. So you have seen from the state of Punjab, that case, and this Partiwala, how he has talked about whether there is a separate course of action or withhold or rejecting the separate course of action available or not. Okay. So in that case, in all the situation, it is mentioned, not really. Okay. So I'll go to the main part to deduce the final answer itself. Okay. That the discretion that is given to governor, that discretion is given under proviso 1 by naming the word may. Okay, that is just to give two options, whether assent the bill, withhold and return the bill. That's all. Example. Okay, so this is the part to be talked about. Okay, now मैं आप लोगों को 196 में जाऊंगा and I'll show it to you full and final what is the things talked about. It becomes clear that there are only 3 courses of action available to the governor to choose from when a bill is presented to him for assent under Article 200. First proviso is not an independent fourth course of action, but intrinsically attached to the option withholding the assent. Okay? It is not a fourth course of action. It is attached. In other words, the first proviso is a clarificatory and only elaborates the procedure to be followed in case option of the withholding assent is invoked. Okay? So, if you see it, there are 3 Article 200 में 3 part है. Okay? Article 200 has 3 part. The first part is called the subjective part. Second part is the first proviso. And the third part is the second proviso. So what जस्ट Pardiwala is saying कि देखिए फर्स्ट पार्ट में ये बोला गया है तीन ऑप्शन ऑलरेडी है, असेंट टू द बिल, विथहोल्ड द बिल और रिजर्व द बिल फॉर रिकंसिडरेशन. नाउ व्हेन withhold the bill is option is chosen by the governor, then the first proviso is going to be activated. It's a clarification. If the second proviso, if the third option is going to be activated or chosen by the governor, then the second proviso is going to be activated. Clear? So what he is saying, first proviso is not a separate fourth course of action. Separate fourth of course of action नहीं है. It is only part of this thing. If he withholds the assent, then what is the next process? The next process is going to follow in the first proviso. It is not a separate course of action altogether. It is just a process followed from choosing the second option. That's all. Clear? Is it clear to all of you? Is it clear to all of you? Okay. Now, coming to the next important part, okay. The use of the expression shall in the substantive part of Article 200 with the expression as soon as possible are used in the first proviso. It means there is no pocket veto available for the governor. So governor does not have any pocket veto because the word as soon as possible has been mentioned. Okay. Also, I have discussed, also he is exercising the powers under Article 200. So no pocket veto means he can't sit on the bills for 1 hour or one year, 2 year. ऐसे नहीं कर सकता है. There is a certain time limit. There is another issue that I'm going to talk about in the coming class where that is mentioned. Okay. Now, governor in the exercise of power under Article 200 does not possess any absolute veto. He is mandated to take a decision from among the three options that are provided in the substantive part of article. ठीक है. उसके पास एब्सोल्यूट वेटो भी नहीं है. एब्सोल्यूट वेटो मतलब रिजेक्ट करके छोड़ दिया नहीं है. दैट ऑप्शन इज नॉट अवेलेबल टू गवर्नर. गवर्नर को रिजेक्ट करने के बाद सेंड इट बैक टू द लेजिस्लेचर. He does not have absolute veto. So governor does not have pocket veto. Governor does not have absolute veto also. ठीक है. So this is the very important part जो मैं आप लोगों के साथ शेयर किया. And last final few words regarding completing the issue itself. Okay. In case of withholding of the assent, governor is bound to follow the procedure prescribed under the first proviso and assent to the bill if it is ultimately presented to him for the second time. Governor may also reserve the certain bills for consideration of the president. However, in no case has the governor been conferred with the power to veto a bill which is presented to him. He is envisaged an intermediary to stop the journey of bill towards becoming an act. So the thing is that there is no पावर और वेटो पावर गिवन टू गवर्नर कि एक बिल को एक्ट बनाने के लिए रोकने के लिए कोई पावर नहीं दिया गया है गवर्नर को. नो पावर हैज बीन गिवन टू हिम. नो पावर. ओके. When a bill comes to governor, he may forthwith assent to it or postpone the grant of assent by exercising the option withholding the assent, but only for as long as till the bill comes back to him after reconsideration. He may forward the bill to president, whereupon the procedure prescribed under Article 201 and the proviso of the Article 200. Thus, in none of these cases can governor permanently keep a bill with him without according assent to it, nor can he declare simplicity without withholding of assent or thereby killing the bill. He does not have the power to kill a bill. ठीक है. आप लोग शायद एक मूवी देखे होंगे, किल बिल वॉल 1, something like that. Okay. So governor does not have the power to kill the bill. Can governor kill a bill? No, governor cannot kill a bill. Okay. That's a very important part. I hope you understood the very first issue. So governor only has three courses of action. First is assent, withhold and return. Third is presidential return. Governor does not have fourth option, that is withhold one and send it back another. ठीक है. Governor does not have it. Withhold के बाद return करना mandatory है. When he chooses to pick the withhold option, he has to return it back to the legislature. That option is absolutely mandatory in that case. ठीक है. Mandatory in that case. Any query as of now? Any query? I'll go to the second part. I'll go to the second issue. Second issue is very, very easy. I'll be able to complete it today itself. Okay. And then the other two issues I'll pick it up next class. Okay. Any query as of now? Any query? Any query? Can I see any query? Do you understand the first issue itself? आप लोगों को कुछ query है that you want to ask? Any query that you want to ask? Okay, nothing really. So I'll go to the next very important part. Okay, that is, अगर आप लोग यहाँ पर देखोगे एक बहुत इंपॉर्टेंट चीज हुआ है, ठीक है, वेरी इंपॉर्टेंट थिंग दैट हैज हैपेंड, दैट इज whether the governor can reserve a bill for consideration of the president when it is presented to him for the assent after being reconsidered in accordance with the first proviso to the article 200, more particularly when he had not reserved it for the consideration of the president in the first instance. So the very important part, अगर आप पूरे facts of the case देखोगे, the thing that has happened, पहले 12 बिल्स प्रेजेंटेड टू द स्टेट ऑफ तमिलनाडु, गवर्नर ऑफ तमिलनाडु के पास, उसमें से 2 बिल गवर्नर ने प्रेसिडेंशियल रिकंसिडरेशन के लिए सेंड कर दिया. 10 बिल्स ही रिजेक्टेड इट, डिड नॉट सेंड इट बैक, बट स्टेट लेजिस्लेचर पास द बिल, सेंड इट टू गवर्नर अगेन. इन सेकेंड टाइम गवर्नर सेंड इट फॉर presidential reconsideration. Now question arise there कि can governor send it for presidential reconsideration for the second time? मतलब अगर आप article 200 देखोगे, if you see the article 200, if a bill is sent it back to governor second time, governor has to accept the bill. Okay, assent to the bill. There is no any other way out for governor. That is there. Governor shall not withhold assent therefrom. It is crystal here. But here in this situation, governor withhold the assent itself. Not only withhold the assent, he chose the third option. So एक बिल को दूसरी बार सेंड करने के बाद ही थर्ड ऑप्शन चूज कर रहा है, that is sending for presidential reconsideration. Can he do that? Can he do that or he can't in this situation? So in that case, Justice Pardiwala said, it's a very important thing. Everybody, if you are going to listen to it, it will be very, very helpful for you. He said the proviso, first proviso is a complete code. अगर आप complete code क्या है आपको पता है तो मैं थोड़ा बताता हूं. complete code मतलब, okay, first proviso is a complete code, means first proviso and second proviso, all the three options that are available to governor: assent, withhold, presidential reconsideration, withhold, assent. If assent is chosen, अगर गवर्नर ने ये प्रेस किया, bill becomes act. Withhold, first proviso is going to be activated. Bill is going to be sent for presidential reconsideration. Sent for the returning to the management बोल रहा हूँ, legislature, क्या बोल रहा हूँ मैं, returning to the legislature. First proviso, so first proviso will be activated. Presidential reconsideration, second proviso activated, and article 201 activated. So what is saying, this thing, first proviso is a complete code. It means they are mutually exclusive. ये तीनों option mutually exclusive है. If governor is going to choose any one of the option, the rest of the action is going to follow. मतलब सर इसका मतलब क्या है? इसका मतलब ये है कि आप अगर withholding the assent कर रहे हो, first proviso is going to be activated. तो नेक्स्ट टाइम बिल जब आपके पास आएगा आपको पास करना ही है. यू कांट रियली सेंड इट टू प्रेसिडेंशियल रिकंसिडरेशन. आप नेक्स्ट टाइम प्रेसिडेंशियल रिकंसिडरेशन के लिए सेंड नहीं कर सकता, बिकॉज फर्स्ट प्रोवाइसो इज इटसेल्फ ए कंप्लीट थिंग. इट्स अ कंप्लीट कोड. सो हियर इट्स अ वेरी सिंपल थिंग. दिस पर्टिकुलर पार्ट, इट्स अ कंप्लीट कोड इटसेल्फ. बिकॉज गवर्नर, देखो गवर्नर क्या किया, बिल रिजेक्ट करने के बाद बिल दोबारा वापस उसके पास आया, he sent it for presidential reconsideration, but he can't do that here in this case. Whatever he has done, he can't. He can do that only in one situation, an exceptional situation. When I'm telling you, when he withhold the assent, send it back to legislature in the repassing the bill makes significant and substantive changes in the bill that will alternate the nature of the bill altogether. In that case, governor is going to treat the bill next time when it is presented as new bill. तब उसको प्रेसिडेंशियल रिकंसिडरेशन भी सेंड कर सकता है. That is only one. Other than that, all the situations are mutually exclusive. Complete quote. If governor is going to choose the first option, assent, assent. Withhold, matlab first proviso is going to follow. Send it back to legislature. Legislature is going to pass with or without the amendment. Send it back to governor. Governor has to assent. Simple. Third, presidential reconsideration नहीं होने वाला. Nothing is going to be there. Okay? So this is the whole process that is going to be followed one after another, one after another, one after another, one after another. Okay? So the process is very simple. I hope you understand, and that's why governor cannot do that thing here in this case. The second time में आप इस particular legislature को नहीं send कर सकते हो. Presidential reconsideration के लिए आपको assent देना ही पड़ेगा. You can't really do that. You are constitutionally mandated, obligated to do that. Okay? So I'll show it to you once. Yeah. There is one Latin maxim to choose that expression of one thing is the exclusion of another. तो अगर आप withhold कर रहे हो तो presidential reconsideration आप choose नहीं कर सकते हो. ठीक है. Now having said that, the most important part I have already shared. Okay, so president cannot choose anything other than the proviso itself. ठीक है. So for the reasons above in the foregoing discussion, मैं final conclusion draw कर रहा हूँ इस issue का, दूसरे issue का, that is, we are of the view the governor could not have reserved the bills for the consideration once they were reconsidered by the state legislature, presented to him without any amendments, particularly when governor sent it back to the legislature. Okay. As a natural course of action, reservation of the bill for consideration having been found to be contravention of the procedure prescribed in under Article 200, thus illegal and void, and any subsequent decision taken by the president on those bills also non-est and is thus declared to be void ab initio. That's how it is. That's how it is the course of action that needed to be taken for the second issue. Acha. Any query that you have, kindly mention in the chat box. Any query that you have, just go through. I have gone through detailed way. I have gone through it. ठीक है, अगर आपको कुछ query लग रहा है, आप मेरे साथ share कर सकते हो regarding this aspect. Okay. अच्छा. I've shared all the things, and I have also mentioned in the first class. आप first class जाओ. First class में I have talked about the first part. आप लोग उसको detail में देखो. Second particular इस case में और भी detail में जाओ. ठीक है? Because this case is important. अच्छा. As some of I have got. Sorry, I've got few questions like that I'm going to discuss right now. What is CLAT? CLAT is there are two versions of CLAT. One is CLAT UG and one is CLAT PG. So we are basically talking about CLAT PG, where the student is going to talk about, okay, student are going to go for LLM. ओके जब CLAT PG LLB कंप्लीट करने के बाद LLM करने के लिए जाना चाहते हैं तब CLAT PG क्रैक करके आपको जाना होता है. CLAT PG के माध्यम से और भी दूसरे चीज कर सकते हो, जैसे PSU दे सकते हो आप, और आप you can go for other things like JAG भी एंट्री आप ले सकते हो. ठीक है. So that what CLAT PG is. CLAT PG as a question paper हम लोग बहुत वीडियो बनाए हैं. यस सर वीडियो बनाए, चिया मैम वीडियो बनाए, आप उसको एक बार देख सकते हो. I have made several videos regarding that aspect. You can go and check those videos. That will be very very helpful for you. ठीक है. Now सारे वीडियोस में मैं एक ही चीज आपको बताऊंगा कि CLAT PG अगर आप देना चाहते हो तो आप इसको फॉलो करो. जो जो वीडियो में बोले जा रहा है, you will be able to crack the CLAT PG. And also, if you haven't subscribed to our channel, do subscribe and press the notification button. Okay, because we are coming up with all the latest videos that you need to go for it. Okay, and जैक के बारे में भी एक वीडियो बनाया गया है, फॉर्म फिलिंग के बारे में, तो वो भी देखो. That will help you. And the next important part that I'll tell you, that don't miss this particular judgment class. Okay, that will be very very important for you. ठीक है, judgment class को छोड़ो मत. वो आपके लिए बहुत हेल्पफुल होने वाला है. Okay, so having said that, I'm going to end it here. Thank you. See you again in your next class, in the next class, and happy Independence Day to all of you. Happy Independence Day to all of you. Thank you.